I'm Lisa Munro. I'm here with my colleague Cynthia Kuehl, and this is the third in our series of arbitration issue discussions from the perspective of arbitration counsel and from the perspective of an arbitrator. Our last session was all about appointing the arbitrator. This, our third session, is about the first procedural meeting, which happens right after the arbitrator has been appointed. I think the first issue to address is, what is the first procedural meeting? It takes place usually shortly after the arbitrator has been appointed, often before what we call the pleadings have been exchanged, so the notice of arbitration or the defense have been exchanged. And it's really the first opportunity for the case management process that I've talked about to take place. It's also the first opportunity for the arbitrator to set the tone of the arbitration and to establish credibility with both counsel and the parties. And so during that meeting, there's an opportunity for the parties to get to know the arbitrator and for the arbitrator to get to know the parties, and also for the arbitrator to get to know something about the dispute, because the whole purpose of the first procedural meeting is to set the procedure that will be customized for that particular arbitration to resolve that dispute. So the procedural meeting actually requires a lot of preparation and planning ahead. And it's standard practice to actually send out a detailed agenda to counsel in advance of the meeting so they can consider and perhaps discuss with one another a lot of the issues, but at least they come prepared to the meeting to discuss them. And some of the issues that are commonly discussed during the first procedural meeting are whether oral examinations for discovery are necessary. And a litigation counsel hearing this would be aghast, because we consider it, when we're counsel in court proceedings, as an essential part of the litigation. But arbitration is very successful in minimizing or eliminating oral discovery altogether, and one of the best ways of doing that is having the major players put in affidavits for their main evidence in the hearing, which usually obviates the need for oral examination because the opposing party understands what the case they have to meet is. Another issue that often gets resolved in a more efficient way is documentary production. In court proceedings, parties are required to produce any document that may potentially be relevant, but in arbitration, it's very common that parties only produce the documents that are necessary to prove their case. And so you can see how eliminating the Ontario Rules of Civil Proceeding method of addressing those two issues can already achieve some of the efficiencies that we talked about in cost savings and time savings in arbitration. Other issues that can be discussed are whether there should be a bifurcation of the proceeding. Should there be a liability part of the hearing first before damages are addressed? Should there be translation if we've got parties from different jurisdictions speaking different languages or documents that need to be translated? Will there be a challenge to the jurisdiction of the arbitrator? If that's the case, it needs to be raised early, and will it be dealt with by the arbitrator earlier, or will it be dealt with later in the merits part of the hearing? So all of those issues and a whole bunch more are on the agenda for this quite lengthy discussion about what the process looks like. And that culminates in what we call the first procedural order. And that is the order that the parties have had a full opportunity to participate in, make submissions in respect of, and in many cases agree to, all of the aspects of the process. It is the roadmap to how the proceeding is going to go from the point in time of the first procedural meeting to the hearing. And it's not uncommon that at the first procedural meeting you'll even set the hearing date. And so all parties know that at that point in time they've got to be ready, and every interlocutory step that needs to be done before then has to be fit in the time in between. And one of the principles that all counsel buy into in this process is that this is a fixed timetable, and unless unforeseen circumstances arise, and they sometimes do, parties are going to stick to the timetable, which means they have to be ready for the hearing dates when they're scheduled, for any motion dates that are contemplated, and for any exchanges of evidence that are contemplated. And that's how you run the efficient process that you and I talked about at the very beginning.
So coming into the first procedural meeting as counsel, probably the most important guiding objective is to remember why your client ever chose arbitration to start with. because the first procedural meeting, as you said, sets the tone, but it also sets the process. And that process can, by and large, achieve a number of the objectives that your client may have had, including the objectives of speed, efficiency, and confidentiality, because that's an important part of the order that you can get at the first procedural meeting. So you need to sit down and think about, what do I want to accomplish at the first procedural meeting, keeping in mind those objectives. I found it funny that you said that part of what the arbitrator wants to accomplish is getting to know the parties, because from counsel's perspective, part of what I want to accomplish at that first procedural meeting is establishing a rapport with the arbitrator. One of the key differences between arbitration and court litigation is that I'm now going to be with this person as my decision maker, either case management orders or at the final decision throughout the process. So I want to get off on the right foot. I have to protect my client's interests, but as counsel, I want to make sure I develop a rapport where the arbitrator already believes that they can trust what I say. And the first procedural meeting is the first opportunity you have to get in front of that arbitrator to talk about your client's case, but to establish that rapport and degree of trust, which ultimately will reap benefits throughout the process. Similarly, if you don't establish that trust, you appear as difficult, the arbitrator is questioning whether they can believe what you say, that's going to follow you throughout the scope of the entire arbitration. So as much as process is important, it's also a good opportunity for you to actually develop that relationship with the arbitrator at that very first meeting. Another of the objectives is that I want to use this first procedural meeting to introduce the process to my client. Most arbitrators do not require clients to attend, and many counsel don't want clients there. And I think sometimes having clients there, some counsel tend to act a certain way in front of their clients, and you can often get more business done without the clients present and without all that bravado getting in the way. However, you've got to talk to your client about what's going to happen at that first procedural meeting. You have to tell them in advance what the process is going to look like. And so this is a really good opportunity to have a discussion with the client about what this arbitration is going to look like. And one of the things you've got to talk to them about in the first procedural meeting gives a really good opportunity is cost. Because one of the things is that there are a lot of potential front-end costs to the hearing itself, like witness statements, that they're not going to see in litigation. But there's also potential cost savings, like, do I really need to be doing discovery in this case? Or can I get away with not doing or doing very limited discovery, which will make it an entirely more cost-efficient process. So I think that whether your client attends or not, the first procedural meeting gives you real opportunities to discuss this process in depth with your client, and you shouldn't miss out on that opportunity. And at the end of it, what you want is an order. And if you get an order that sets up a process, you've set yourself up well for the entire dispute to come. And you're able then to know that the parties will be kept on track by somebody who is case managing the case. And that's ultimately what you want to accomplish at your first procedural meeting. So far we've been talking about all the pros and all the benefits of arbitration and how it's all going to move smoothly. But in our next episode, we're going to talk about what happens when you actually want to challenge the arbitrator and perhaps make a different decision about who's going to hear your dispute.